Everybody, we'll start off this hearing with a Kerikeri, which I understand will be performed by you, Mr. Chair.
Thank you, Mr. Chair. Tūtawa mai I runga, tūtawa mai I raro, tūtawa mai I roto, tūtawa mai I waho. Kia tau ai te mauri tū, te mauri ora kia te katoa. Haumie, tuie, tākie. Mr. Chair, before we begin, I'd like to probably take the opportunity to recognise the passing of Mrs. Burkhardt, the mother of Teresa Burkhardt and Harry Burkhardt, both long time council process employees and former chair of Tekua Respect. So I'd just like to acknowledge that Mrs. Burkhardt is being put to rest today.
Thank you very much, and I think on behalf of the panel, all members of the panel, we extend our condolences to Ms. Burkhardt as well. She's a really respected member of the hearings reporting team, and so we wish her well and look to seeing her again soon. Okay, so tēnā koutou katoa, nā mai haere mai ki tēnā hui, kua waka Scott Tabuino. Morning everybody, this is hearing number 14. This concerns all things related to urban zonings, crossing the gambit from residential to heavy industry. My name is Robert Scott, I'm the chairperson for these hearings. With me to my right is Councillor Kelly Stratford, and my left, Alan Watson, Commissioner Alan Watson. So this is a hearing under the Resource Management Act to consider submissions and further submissions on the proposed Far North District Plan. We've been appointed by the Council as independent hearing commissioners to hear submissions and make recommendations to the Council on any changes to the plan as notified. We're not intending to issue interim recommendations at this stage, and we'll be hearing all the submissions before issuing a complete set of recommendation reports. That said, we intend to hold interim deliberations at the conclusion of each hearing topic. And we will be holding probably deliberations following the hearing of evidence while we're up here at Kerikeri. My background is in planning. Your background, Commissioner Stratford?
Oh gosh, hospitality.
As I'm understanding local.
Yes.
Representative?
Yeah, planning, I guess, yeah.
So we're all independent. Are there any procedural matters that we need to deal with before we proceed? I don't think there were any that are
No procedural matters, but I will cover something that I was rolled through evidence in my hearing presentation.
Okay, that's good.
Mr. Chair, perhaps a note as well on the announcement of government last week, last week, whichever week it is. Last week, so the government announced its intention to change the law to preclude any further council initiated plan changes and any plan changes of like that have not reached hearing stage. Obviously, we are very clearly very deep into the hearing stage. My understanding of the approach from council at this point is that we intend to continue. I think it's important to probably have that on record at this stage, and that will stay the same until if it changes.
Yeah, no, thank you for that. And I was going to raise that we've received at least one note from a submitter who was going to appear, but has chosen not to appear because they think that these hearings will be coming to a close because of the announcement of the Minister. That's obviously not going to be the case. And we agree with you that this process has been in train for some time, and those hearings have already been set down, and we'll be continuing right through to the bitter end. Anyway, thanks for clearing that up.
Can we let that submitter know that?
Yeah, I think we'll, through AK, I'll let them know that we will be continuing right through.
Especially given it's a local planning consultant.
They should know. Sorry.
Yes. Okay, right. So we've had a bit of a change to the schedule, and a number of submitters have withdrawn due to illness, which is a shame but fully understandable. So that means that we have quite a bit of time in our hands. So Ms. Trina, you're going to do a summary. You've got all these urban zones and you can take your time to take us through and summarise what we're about to hear. So it will give you a little bit of latitude if you'd like it, and we'll hand it over to you.
Thank you, Mr. Chair. Tēnā koutou katoa, ko Sarah Takiwala. I'm Sarah, I'm the Senior Policy Planner at Arnold District Council, and I was a report writer for the urban zones. They included general residential, mixed use, light industrial and heavy industrial. So I'll just take you through my parents' presentation. Feel free to stop me if you want to ask a point of clarification. I'll try to slow it down, but just give me some feedback.
Yep.
Okay, so I'm going to cover an overview of the submissions, some of the key conclusions zone by zone, and then I'll touch on the evidence and statements at the end. So we had a number of submissions on these zones. So 816 original submission points, which ended up in 1,173 further submission points. So these came from a range of groups: central, local government, local planning companies, EV authorities, hapu and marae, key interest groups, individuals and others. And they covered, a range of matters. Through my section 42A, I've recommended the introduction of a medium density residential zone and a town centre zone. These two zones will apply to Kerikeri, and at this stage I've just recommended the introduction and signalled my direction for these zones in Kerikeri, but further details around the provisions and the spatial extent will be provided in hearing 15D, so that's to come beginning of October. Consequential to the introduction of a medium density residential zone, I needed to do something about the multi-unit rule that we have for Kerikeri. So I recommended the removal of the multi-unit development rule for Kerikeri so that we can focus that type of development into the medium density residential zone.
Now, just to clarify that, so we're going to see those provisions at hearing 15D.
Correct. So they'll be available in the section 42 report for this
Yes.
meeting. So just looking urban-wide, we made some key changes to the obs and poles throughout the whole of the urban zones to refer to planned character. This was to make reference to a well-functioning urban environment, noting that we now recognise that the council is now a Tier 3 authority under the NPSUT. Also through the obs and poles, we recognised greater consideration of reverse sensitivity and allowed consideration of alternative telecommunications options. One of the other things across all of the urban zones was inserting a new definition of supermarkets and associated rules for them. One of the key other things we did across the urban zones was introduce a waipapa control area. So it's for waipapa that actually provides for commercial large format retail and supermarkets. This is to recognise the different kind of environment we have in Kerikeri and the type of businesses that have established out of waipapa.
So yeah, just in the waipapa, it's predominantly light industrial zone, is that?
So it's all light industrial zone, there's a heavy industrial at the back into the side of waipapa,
Yes.
but recognising that currently a lot of our large format retail is located in that location.
Yes. Is there any intent to look at any new town centre zoning at waipapa? Or is that all going to stay light residential? And I accept if you haven't made that, I accept if you haven't made that decision yet, but it'll be interesting to know where you might be going if you have.
Yeah, James,
Yes, Mr. Chair, I think the character of waipapa is quite specific and distinct from, say, Kerikeri, so applying to town centre zones probably not appropriate. I think you'd see in the report that we've probably at least alluded to the fact that our intention was in accordance and in alignment with the Kerikeri Waiwaka Spatial Plan, particularly that we had intended to bring a large format retail zone in as probably phase 2 of this planning phase of this PDP and also the implementation of Te Whatukuria. Obviously that's a little bit challenging now, but I think there is I guess a reasonable argument to have a bespoke set of provisions aligned with large format retail to adequately and appropriately manage and direct development in that location.
Thank you.
Thank you. We also, across the urban zones, included amendments to the coverage standards to better manage the stormwater effects and provide consistency with the plan and wide approach, which was decoupling of the engineering standards.
Can you just take us through generally what those amendments are?
So the amendments were to, if you didn't comply with the coverage standard, which is different percentage for each of the zones, you would have to acknowledge compliance with the site suitability report.
Right.
And then through the assessment criteria to that as well, we've introduced downstream effects as one of the components.
So there's still a percentage coverage.
There's still a percentage coverage,
yeah,
which is largely being rolled over from the operative plan.
So non-compliance with that coverage standard is what, restricted discretion or?
Correct.
Yeah. Okay. Yeah, thanks.
So looking to the general residential zone, we've generally been more enabling in this zone. So we've made amendments to the residential intensity rule to allow one residential unit per site or per the 600. We've reintroduced that 600 threshold back in, and we've looked at a restricted discretionary framework for 2 units, which was previously discretionary. We also allowed, had a permitted activity for minor residential units as well. And there is amendments to several of the standards in the general residential zone. One in particular, the facade length standard to a fencing standard, because it was easier to determine exactly what we were trying to control. We decreased the outdoor living standard slightly and introduced a setback from the Kiwi Rail destination boundary.
Another thing I would note, Mr. Chair, is that these changes should be viewed in conjunction with that for some of the rural zones, particularly rural residential zones. So I think we made a realignment here between the land use and subdivision provisions, and also introduced other provisions for minor dwellings. Obviously the government is going to provide the granny flat provision as part of the yes, but overall there would be quite considerable enablement, further enablement of residential accommodation recommended by staff.
Is there an exposure draft of that NES yet? Do we know particularly what the standards would be?
I think in some instances it might be more enabling. I'm not quite sure about the distance to the primary dwelling provisions, whether they're in there. I think that suggesting 60 metres squared, I think we're a little bit larger than that.
I think it's 65.
Yes. So, yeah.
To be honest, I'm actually writing up those interim provisions in the rural section on minor units at the moment.
I haven't seen that.
And so you're matching those same standards more or less?
From the information we have, we're aligned with them.
Yeah.
I think
But
we're
yet to know,
yeah.
we're yet to know where the government's national standard would be. But you think, from what you've seen from them, that you might be a little bit more enabling in terms of square meterage?
In some areas,
In
yes.
some,
Yeah.
Yeah. Did you say that the government was talking about 60?
I thought it was 65, James is just confirming.
It seems to me that 65 sort of been adopted
Yeah.
almost nationwide by most councils seem to all agree that a minor dwelling should be 65. They have different things about how close to another dwelling
Yeah.
they are, and things about access and how you include or not include a carport, those sorts of things. But it seems to me that everyone sort of arrived at that number.
Yeah, there's also...
So it would be, you'd hope
So
that the government direction would also be consistent.
So, I mean, I've seen, I think in my work, I think I've seen up to 80 or 90 even.
Oh, really?
Yeah, but I'm just looking here at the document from MFE, which is proposed provisions that was dated 29th of May. And proposed provisions, internal floor area is 70 square metres, up to 70. Look, it probably is a simple, I guess once it lands, understandable land before you issue decisions, that's probably a fairly easy one to align.
And I'm assuming that we would then respond to that in light of what, is it the sort of council position that you would want the proposed amendments that you're making now to match what a national standard would enable, or at least be enabling, at least equal to?
At least equal to. I think there are some pragmatic reasons for that, Mr. Chair. I think we do have submissions on general submissions on sites and monodrums. Certainly the introduction in some zones. So there would probably be scope. We'd have to probably specifically identify that for you. But yeah, I mean the requirements is that depending on how they outline the preamble and the use as to whether we can be more conservative or more enabling, I suspect that we won't be able to be more conservative in terms of the floor area. There's probably a fairly good swing at a guess there. Yeah, I think that my recommendation would be to.
So I think it would remain within our scope to match the two up, notwithstanding what we hear now, the best guess. Okay, well that's quite helpful.
Yeah, the Auckland Council recently made a decision on a minor household unit at 80 square metres as a restricted discretion, which
I think the further south you go,
makes a nonsense. Makes a nonsense of the provision, quite frankly, but it's a personal opinion. Just on that 3 metre setback from the designation boundary for the railway corridor, that's still not consistent with what Kiwi Rail are seeking, is that correct?
That's correct. Still seeking the 5 metre setback.
Do you have a view on that? Apart from the fact that you can agree?
Yeah, my view is around 3 metres should be enough access to maintain the corridor. This has been talked about through the previous zoning hearings.
Yeah, so that differs from what you were recommending in the rural zones, which I think was a little bit more than that. But then, I mean, it's really an academic exercise, quite frankly. And I remember asking them the question, when did you stop running trains? And they said in the 80s, and why did you do that? Well, because it's too expensive to maintain. Has anyone had a look at the tracks since then? No, not really. So if they were too expensive to run back in the 80s, I mean, we've got no idea what condition they are. And it would be a mammoth amount of investment. But having said that, future-proofing the plan.
Maybe you need 5 metres for the storage of sleepers.
Well, I was going to say, you need 5 metres, for all the noisy e-bikes that'll be riding along it, possibly what its long-term future
Yeah,
is.
I would also note there was substantial evidence given one of Mr. Kenton, Baxter's noise hearings as well, substantially on those matters as well, even in terms of where we measure, whether it was the designation boundary, for example, as opposed to. So all those matters are sort of together probably need to be looked at as a whole. We had some really good positive discussion with, particularly through that hearing, Mr. Baxter and Kiwi Rail. Although we didn't agree, the conversation was really good. But I think we ended in a very similar place to you, Mr. Chair. Are we imposing, essentially excessive requirements on people for something that may never occur?
So I'm just sitting here thinking, where, like Kauhau and Moeroa is the general residential areas affected by rail.
That's as far as the rail goes, right? It only goes to Moeroa, doesn't it?
And
or just south.
Yeah,
Should be
that's right.
Those
Sorry,
are
and then the
present.
rest of it is rural.
Yeah, so
Yeah.
Moeroa is actually our settlement zoning as well, so it's Kaua.
Yeah.
Yeah, I mean, it was interesting because we actually had extensive evidence. Miss Hepplethwaite showed up and did her diagrams of three-story buildings and bits of wood falling off the third story and travelling down into their rail corridor. And I thought, well, and then we were thinking, these are we would look at, this was rural zone evidence, and I would have thought that that evidence was more relevant to these hearings, because that's where you're literally possibly going to get development, certainly even near that scale. So I'm assuming that that same evidence that she presented still would relate to these urban zones. Is that how you sort of had regard to that?
Yeah, correct.
That quite extensive evidence that they prepared? Yeah. So your recommendation has had regard to that previous evidence?
Yes, I have regard to everything previously discussed.
Yes. Yes, I understand, you know, should we write a rule that we don't, that won't harm anything? What's the harm of putting it in? But I suppose we also have to be cognizant of, are we reasonably certain that this is a rule that may actually get triggered?
I think it's a question, Mr. Chair, right up section 32, efficient and effective.
Does council have a view, does council officers have a view on that, efficient and effective?
I'm comfortable with the recommendations made by officers today on both the rural and urban. So
Yeah.
on the matter.
Okay, so on balance, still efficient and effective. Great, thanks. Let's jump in the middle.
I'm still stuck on the uncoupling of engineering standards, and that was the point that you mentioned on the previous slide was around the coverage, and then there's been some discussion around like uncoupling from the engineering standards throughout the hearings. Along the journey, has consideration been given, and especially for urban zones, been given to the impact on accessibility? One of the reasons we reviewed, or council reviewed the engineering standards, was to ensure that like access ways were done to today's accessible, footpaths and stuff were done to today's accessible standards, rather than, you know, what was done in the past. And in the urban zones in particular, like around Paihia and Kerikeri, we get a lot of complaints about you know, stormwater drains being shaped so that, yeah, they catch the water, but somebody on a mobility scooter ends up in there with it. So have you been taking accessibility on the journey of engineering standards?
No.
Yeah, so I think that's perhaps more about how the systems and processes work as opposed to the substantial content of what's in there.
Okay.
So essentially by removing the standards, they still stand as a council policy document and a reference document to what can be acceptable, particularly when receiving assets from the public. And
yeah.
So that's still very much part of those. So it doesn't go away.
So when a developer goes for a consent, they still have to be, they're uncoupled, but they still are checked off by an engineer.
So the mechanisms and tools that we're going to use will land probably in subdivision chapter, so there'll be more specific flesh on the bones there. I would just say generally, say particularly when council receives assets from developers, that while it is removing the engineering standards events, we don't have to go through a plan change every time we update them to bring those new changes in.
Yeah.
But they will essentially be a method of compliance or a reference document for a developer to go to. Okay, what would council expect in terms of its receiving assets back from that community? Again, but we haven't completely reported on that as of yet at this stage. But I guess the bottom line is it hasn't been pushed out.
Yeah.
So it hasn't been lost.
Yeah. Okay. All right. Well, I better keep a closer eye on them going forward. Thank you.
Moving on to mixed-use zone key conclusions. So we've also made this zone largely more enabling. So we made amendments to the visitor accommodation residential activity So previously this was a discretionary activity if you wanted to do visitor accommodation or residential activity on the ground floor in the mixed-use zone. So we've changed the activity status of this to a restricted discretionary activity outside of the pedestrian frontage. So ground floor visitor and residential activity in the pedestrian frontage area is still an occupying activity. We've removed the reference to the ground floor area in mixed-use zone rule 1 and applied this ground floor area rule to the activity types rather than just in the general rule 1. We've introduced new rules for community corrections facilities and supported residential care within the mixed-use zone, and we inserted a minimum net floor area for the mixed-use zone for residential units. Some of the key things we looked at for mixed-use zone. Any comments?
Yeah, reading my mind. So I know, we've reviewed some of the papers and the like, but the status for community correction facilities in the zone.
Yeah, so the activity status is discretionary for the mixed-use zone.
Right.
And we've made that more enabling in the light industrial zone. At the time we thought that was the best zone for that type of activity. I understand from the evidence we've got a little bit more insight as to what that activity might actually be. So there may be some need to revisit that.
Yeah, it's a matter of people understanding what community corrections facilities was, from the reports it involves quite a bit.
Yeah.
That, to my mind, that seems to be more enabling than it was.
It was previously not an activity listed in the zone, so it fell to a discretionary activity. But by providing for it in the light industrial thing as a whole, we've made it more enabling. But yeah, as mentioned from the evidence, I do get a clear understanding of what type of activities they are. So
That's where that evidence is quite good.
Yeah,
Whatever it was,
we did have some lengthy discussions about what that actually could be, and we looked at like the overnight component if there was that involved in it. So yeah, we did give it some greater consideration, that's for sure. But I think
we are going to hear from Mr. Grace later on this morning, so it would be helpful maybe if you could respond to his evidence afterwards if you got a response, and we might sort of see whether we might be able to have a discussion between the two witnesses to see where that takes us. So I think we're interested in a few of these issues as well, and what I'm particularly interested in is why does the activity status have to be more restrictive in the mixed use zone, and what are the effects that we're particularly interested in avoiding. We don't, but certainly just foreshadowing that and sort of articulating that, and I want to be putting those sort of same questions to the witness as well.
So that's separate from, and this is an issue that came up recently, people complaining about, iwi building houses in a farming area for discharged prisoners. That's different, isn't it? Or maybe I need to ask
Mr. Grace is probably the one to ask for that because it's quite complex.
For me,
I don't think
houses.
it's Papakahinga.
That's just houses. They're discharged, but they're on a path to rehabilitation.
I think both Commissioner Watson and I have been involved in other jurisdictions where this whole thing about justice and correction centres, and particularly where residential is enabled, and I'm wondering whether that's the element that you sort of, when you see mixed use zone, you sort of see it more as a business zone. I suppose it's enabling residential. So
it's everything, isn't it?
So
Okay.
So
thank you.
Mr. Chair, I think part of the commentary and narrative is that obviously we went with one commercial zone across the entire district as notified. I think what we have seen in the report and through evidence, and we'll probably respond further to evidence that we've seen, is that provides a particular challenge mixed use zone, and actually Mr. Batten was one of the people who led the discussion. It tried to do an awful lot of things, and I guess it, particularly around enable residential quite strongly, and there's a lot of submissions towards enabling residential activity in this use zone, and the range of commercial zones, commercial activities that would occur in that zone. So there's an inherent tension here, and they don't necessarily, the zone doesn't necessarily, as notified, reflect a lot of the nuances between settlements and areas that require slightly different management or more nuanced management to reflect what's there and perhaps what we want. And certainly on for example, what does mixed use look like in Paihia? Is it the same as it looks in Kaikohe? Is it the same as it looks like in Kaitaia? Is it the same? No, it's not. So I think what officers have kind of taken a more of a top-down look when looking at these submissions in terms of how does these things work? How could they work? How would they best work? And I think officers we still have an open mind in terms of where we are with things. I think we've seen some really helpful things in terms of evidence that we'll look to probably respond to. So I think some of these activities, where they should go, which ones should be enabled, how we enable them is tied up with the limitations that we had, I think, in terms of what we had to begin with.
And obviously, are you looking to mirror the approach taken with the mixed-use zone with regards to this activity in the town centre, the new provisions for the town centre zone, or is that still in the mix?
As in the zone provisions?
Yes, so your town centre zone provisions we're yet to see.
Correct.
Is your thinking at this time that you would mirror the same provisions that you're recommending here for that zone, as the same as the mixed use zone, or would it be slightly different?
Slightly different, I would expect them to.
Activity stages in particular?
Yeah, I would expect them to be different.
Right, okay. But the town centre zone still enables residential too, doesn't it? Yeah. Okay, I'll be interested to see what those reasons are. Okay.
No, that's right.
Especially given the fact that a lot of ministry agencies like to place people in town centres so they're close to work and services. And of course there's the differing idea from some submitters that they don't want to see those corrections and provisions people in the middle of town centre.
Yeah, well, I mean, what normally happens is that they say town centre zone, well, it's a residential zone. And these facilities, are going to be housing prisons. And that sort of, until the end of the spectrum, that you end up sort of, the concerns, rational or not, tend to sort of to be focused.
Yes.
It's not easy though, is it? It's not an easy issue to resolve because obviously you look at Patama's requirements and the genuine need to undertake rehabilitation services in the community. And then you've got these fears of people about their amenity in there.
Yeah.
And everybody wants prisons, but nowhere near they live.
Yeah.
Yeah, I acknowledge the point of Councillor Strickland that you can't assume that these people have driver's licences, can drive.
Yes.
There needs to be a reasonable expectation of accessibility to these locations.
And public transport obviously is not very well provided in any of these communities either. So.
No.
And they can't, we're assuming they can't afford to take Ubers.
Similarly, sir, I think this is a big question for particularly people who have a presence across New Zealand. Is there a reasonably likelihood that actually we're going to receive investment from either the government or private companies to actually undertake the activities for which they're requesting provisions for?
Yeah.
I think that's a reasonable question for the panel to ask.
Okay, no, thank you. That's an interesting discussion. And I'm sure we'll be discussing it further later on today. It's really quite good. Right, industrial zones.
Yeah, so looking to the industrial zones, we've got a light industrial zone and a heavy industrial zone, and we were just chatting previously about, we did quite a bit of work in differentiating the two zones. So from the national planning standards, we just have a definition of industrial activity that we wanted to work with. So yes, we did have a few challenges in working out the best mechanism to deal with the type of activities we expected in each zone. Resulted in the development of light industrial activity definition. Through the industrial zones, we had trade strain and waste management industrial zone, and an amendment to the industrial zone to increase the height limit, and amendments to simplify and clarify the landscaping requirements. And we removed the building and structure area limit. So I did removing boundaries between sites and the industrial zone. Those are some of our key changes.
Are you changing GBA to GFA as well?
Yeah, we may need to look at that for planning. But we removed, so the gross business area, we removed that limit from the industrial zone and put it to square meter.
Would that be based on GFA?
Sorry, I'll just clarify that before I say the wrong thing.
Because this sort of GBA to GFA thing,
Yeah.
it's a plan-wide change.
Yeah, sorry, I'll just clarify that.
Unless there's a particular argument for having
GFA, sorry, that's correct.
Well, why do you back for a 15-metre height limit when the submitters are seeking 18 metres and providing evidence to support it?
Yeah, so this was a compromise when looking at height limits throughout different heavy industrial zones nationwide. And we previously had a 12-metre height limit, enabling it to have 3 extra metres. We thought was a good compromise, but I do take the evidence that we have received from May 8. Yeah, and there may be some additional work we could do in the light industrial zones around height.
I suppose the question that arises out of that is whether you set the height limits on the basis of compromise or on the basis of data that we receive. And when you're looking at that area to the south of Waipapa, whether 15 metres is necessarily any better than 18 metres.
Yeah, I take your point there, and there is extra evidence that we've received through this process that can help us understand.
Yeah, I'm certainly not suggesting that's what I think necessarily what we think, which is crazy.
Can anybody remind me what maximum height in the rural zone is? And are these similar heights? I know maximum height tends to be sort of quite enabling in rural zones because of things like grain silos and dairy, milk powder.
12 seems to be
12 is indicated, but we will just clarify that for you.
Often a question put to commissioners in rural areas is how tall does a dairy factory need to be if it's making milk powder? My understanding is that they sort of spray the milk at a high level and it falls, and as it falls it dehydrates and turns into powder, and you need a certain amount of height. Does the height, have you considered something like a dairy factory which you would think could locate as a light industrial activity? I've been involved in a proceeding where they argued hammer and tongs about whether a dairy factory was heavy industry or light industry. Putting that aside and assuming that it is, would that height be able to accommodate a milk powder
Yeah, I don't...
making building?
Yeah, I don't particularly know the height of a milk making building, but I would assume it would be around the 20-metre sort of
I think they might
height.
be a bit higher. I mean, having said that, that would probably be enabled. You'd probably need to consider.
There'd probably be an application of some sort anyway for
Yeah, most likely.
I can't imagine how many dairy factories, additional ones that we would need in the district, to be fair. Your point is taken. My experience is quite often they actually don't occur in, well, if they occur in light industrial zones that are rurally located, they're not necessarily linked into infrastructure because of the significant impact that they put on wastewater treatment plants in particular. Horrific for wastewater treatment plants that most often have their own. So I would suggest that yes, they probably have a more rural outlook. And I'd say yes.
No, point taken. Yeah. Okay, good. We've got a couple of questions around these issues that you're wrestling with as well.
So there's 12 metres.
Yeah, that's correct.
Yeah, 12 metres, isn't it?
Yeah.
And you're recommending 15
15
for both?
for the heavy industrial,
Yeah.
remained at the 12 for light industrial zone.
And that's the main freight one, 18 for both.
I think it
Yeah,
was 20 actually.
20?
Yeah. Yeah, so I did read the evidence, I've just forgotten the numbers.
Yeah, I thought it was 18, but
Actually, I went and had a look at Auckland, and I think they're 20. But they hadn't said that, that's Auckland.
generally people outside of Auckland don't want to hear about Auckland.
We'll need Auckland at some point in our life.
Yes.
They are looking at a 20-metre height limit for road signs.
Yeah.
Or alternatively, a 20-metre and 12 metres within 15 metres of the residential,
Yeah.
residential zone.
I mean, one of the other things that we often hear is Whangarei is doing this. I mean, that becomes the immediate comparison that's been presented to us multiple times. You know what Whangarei does?
I think that might be
Do we
20
have
as
it
well.
on?
Yeah.
I think we're moving to an 18 then. Isn't it better on the stormwater? Like creating more height versus more spill?
Yeah. One would
I'm not
imagine.
an engineer.
Yeah, maybe it would be,
And it comes down to the functional needs. I mean,
Yeah.
this is where I think the main freight evidence could be quite helpful. Because I don't think they're wanting more than what they need.
Well, they're just concerned
They
that
just
they
want to build their utilitarian sheds, right? And
evidence. But they, but they don't want to see yard space wasted and or used unnecessarily, I guess.
Yeah. Yeah, I take your point. We did, as I mentioned, remove some of the setback between the zones and have done some things
Yeah, which is
to
good.
enable full use of sites in that respect. So.
Yeah.
now, one of the things I'm also interested in the impermeable surface standard and how that works in with coverage. And is Waipapa reticulated?
No,
No.
my focus.
So none of your industrial zones have a reticulated sewage system, waste or stormwater in particular, which I think would be.
There are a couple that, or
Yeah.
at least one that's got their own,
Yes, I would need to seek clarification on that.
but we don't have any time.
At Waipapa, there is no reticulation, and our heavy industrial zone, no, but I would need to clarify some of our light industrial zones in the
Yeah.
district.
So is the presumption then that all light or heavy, all industrial land needs to provide its own on-site servicing, or are there package plant that they will feed into? Is that going to be the biggest constraint, no matter what your coverage enablement is? Is it the ability to provide on-site wastewater and stormwater discharge? Is that going to be the biggest limitation to establishing GFA?
Yes, I largely think so, but we are assuming that our light industrial zone would be connected to reticulation. Our heavy industrial zone not. But yes, as for example at Waipapa, they do have to provide their own servicing.
Right.
So, yeah, that would be.
So that's where I think possibly our engineering questions might go to, which is, because I think what threshold's 15 at the moment, 15%?
10?
And heavy industrial.
Yeah, 10 and 15.
Yeah. Which means if you want to build a large building, you need to have a really big site. And I thought, what I think we're going to be interested in, and we don't have to have the answer yet, is there expert engineering advice that goes behind that 15-metre threshold?
That 15-metre threshold is a roll.
15 metres.
15%, yeah. So 50% threshold is a rollover from the operative plan.
Yeah.
And we haven't done any further catchment management modelling, and we don't intend to at this stage. So.
Yes, we have evidence that says, well, that 15% threshold is unduly restrictive, but it may not be if it's necessary to manage internal discharge of wastewater and stormwater. So I think we're going to be interested in the sort of factual basis, the expert advice. So maybe you could get in touch with those experts. We have to wait for the end to see, particularly if that's a rollover, what the, I know the at the time you set that threshold in the operative plan, technologies have improved. Does it need to be 15% now, or is it potentially a higher number? Or maybe it still needs to be 15%. Because it seems to me that's going to be the limitation on the scale of anything in those zones if it's not particular.
Your experience, Mr. Chair, in Auckland, you'll understand that, for example, there's a lot you can do to meet those requirements, and I think Ms. Trinder has identified that through amendments to assessment criteria, those matters will be brought. It perhaps puts a site-specific solution onto the developer in that instance, and I think realistically, particularly where there's a hit and miss in terms of either availability or capacity of stormwater, that's probably appropriate to consider approach at this stage without further technical input that we don't have at this stage. So, I think the wonderful approaches that people have nowadays for storage of water before it's disposed, that people don't see, don't understand, don't know, but it is at huge cost.
That's right. That infrastructure is not cheap. And a lot of people say, oh, well, we'll just make the whole roof of our industrial building a green roof until somebody prices it up and realises how much more structural engineering you need because you're going to be having to cater for all those plants being soggy. Anyway, I'm sort of interested as to why, is that still fit for purpose? Is that the number is still fit for purpose, given that it's a rollover of the operating?
I think we're indicating at this point in time the level of information we have. The answer is yes, but obviously we will investigate to the best of our abilities whether that's the case. But again, with inconsistent availability and capacity, that site-specific development of stormwater infrastructure based on previous services is on the face of it appropriate in my view. So we'll get back to you.
Sure. Okay. Right, okay, moving on. Are we done with the summary of industrial zones now?
Yes, we're done with the summary. Moving on to the evidence and the statements that we have available. So, as James has previously spoken to, we have evidence that requests to permit visitor accommodation on the ground floor and high here. So as James has just mentioned, we are looking at options around this at this stage, and we think it could be appropriate. Some of the other evidence was around an enabling pathway for supermarkets in the mixed-use zone. So as mentioned, we did introduce a supermarket framework for the urban zones. Some of the other evidence that you'll hear is in relation to urban design considerations. You'll hear evidence in relation to the community corrections facilities in the mixed-use zone, and we've just had a conversation around that. We need to explore that a little bit further. We talked to increased height limits in the industrial zones, so we recognise that this may be an area we need to have a look at further. New definitions for retail activity, food and beverage activity, and deletion of large format retail. So this is evidence from McDonald's in being clear on the types of activities and what they provide for. We've got evidence on auxiliary activities in the heavy industrial zone, alternative stormwater provisions, which we too have just touched on, increased setbacks in relation to the key rail designation and their boundaries, and evidence around the request for light industrial provisions to enable renewable electricity infrastructure. Since the release of the Section 42A, I have been in contact with Radio New Zealand and have made amendments to General Residential Zone Standard 1 and Light Industrial Zone Standard 1, which are both the height standards, to include a note related to the need for consultation with Radio New Zealand when a building or structure is greater than 40 metres in height within 1,000 metres of the car or transmitter. And that's consistent with the rural zone recommendations. Yeah, so I've made, I'm recommending that amendment.
That seemed quite a strange or quite a specific sort of provision.
Yeah.
That, you know, if you want to go there, you need to talk to somebody else about it.
Yes.
I guess it would work okay because it's a one-off situation, but yeah. Yeah.
That's considered critical infrastructure, and there are New Zealand, you know, radio service.
Yeah.
So yeah.
Or being hammered by the critical infrastructure people, and I think we had a fair bit of information about that.
So this was consistent with the rural zone recommendations, and it affects a small portion of Awanui, which is general residential zone and light industrial zone. So yes, I recommended a note.
Yeah.
Yeah, I was just going to say this is consistent with the position you've taken in other zones. So.
Correct.
Yeah.
Yeah.
Okay.
So that's all I have in my presentation. I'm happy if you have any further questions. Otherwise,
It's good that shows that there's ongoing sort of work between yourselves as officers with the submitters in terms of sorting some of these things through, which makes it good.
Yeah, I think when we're going to have our first actual witnesses, we're probably in about 40 minutes time. So what we could do is we could ask some specific questions about some of the evidence that's not being presented. Normally at the end of the proceedings, we have a discussion about all the evidence we received that's not being presented. I'm just wondering, you know, I mean, we could just adjourn and come back at 10:50, but we could actually spend some time going through that, some of that evidence, and just asking you some matters to address in your reply, or whether you've got anything to say about those. Obviously you've read all of those statements as well. Is there any particular evidence that isn't being presented that you'd like to make a comment on, that you were going to probably talk about at the beginning, but could talk about now?
You probably need to hear the submitters.
Well, they're not presented.
Yeah.
We're talking about those people who chose not to present.
I had some questions for the officers on some of the submitters that we're going to hear from today.
Okay, go for it.
Well, we were going to hear from Mrs. Amsler, but in her submission, in your comments, they conflicted on, and I was a bit confused. So they argue that they should have the different zone because they're close to connections or are connected, are on services. So I wanted to understand why staff considered it more appropriate to leave it as an existing zone despite its location near existing urban areas and the services, wastewater and water.
Okay.
Amsler's submission,
Yeah, in relation to the Amsler submission, the point that you're referring to is actually rezoning point, and that will be considered at hearing 15C.
Oh, right, okay.
So that's, yeah, their request to be rezoned from rural lifestyle to general residential. And I am across that submission point, I just haven't talked about it and considered.
Cool, okay. And there was one point in there that staff said that, the officer said that it would be best dealt with through a resource consent application.
Oh, okay, so you're referring to their submission point relating to setback from vegetation, I
Yeah,
believe?
that's it, yeah.
Yeah, this seemed like a really site detailed submission point, so I would have to check exactly what they were requesting, but my recommendation was that this seemed like a really site specific point. And that
So not enough other people were affected by it, so.
that was my recommendation at the time.
What else did I have?
I've got some other stuff on Amazon.
Oh yeah, you go to AMSLA, yeah.
Yeah, just on that Amsler and the evidence that McPhee put in, where they're looking at the amendment to remove the requirement for residential activities and visitor accommodation to be located above ground floor within that mixed-use zone, outside of the pedestrian frontage overlay. What was your recommendation on that?
So my recommendation on that was a wholesale change to restricted discretionary activity outside the pedestrian frontage.
Yeah. So that provision would still stay, but it would be an RDA. Yeah. Why not look at removing it altogether? I thought that evidence was very good.
Yeah, as I mentioned in my overview, I do think there is merit in the evidence received. At the time, we took a wholesale blanket approach to the mixed-use zone, and I don't think it's appropriate that we will be enabling throughout the mixed-use zone for visitor accommodation and residential activity on the ground floor. As mentioned, there's different qualities for pie here, and it could be appropriate.
Yeah, because there's a similar request for Parakaiko as well, around the Reno place. Yeah, what's it take to get a planner to move towards having something as a permitted activity?
As we previously talked about, the mixed-use zone has a large range of activities, I guess. Its primary focus was a commercial zone, but if we're completely enabling residential activity on the ground floor, there could be some conflicts, and I still think it is appropriate in most cases to be a restricted discretionary activity.
Yeah. In the case of Pai here along Marsden Road, a lot of that activity is there now. Whether it's going to change or not, but I just think of the gentleman with the restaurant that's set well back from the road, and he came along to one of the other hearings, and he said, I was here 10 years ago, and I got sorted out then, now I'm going to come back and it's the same arguments again. Would we realistically ever see a pedestrian veranda over the pavement outside his restaurant? Would make a nonsense of the heritage qualities of the building, apart from, on the face of it, no need for it.
So that's in relation to the pedestrian frontage overlay. I'm not too sure of the location that you're actually talking to. But yes, as consideration of that evidence, I do think the activity types in Paihia with the visitor accommodation strips both to the north and to the south of the township being a bit more elaborate could be appropriate in that location.
Yeah, I mean, there's arguments either way. I mean, at the end of the day, it's a tourist centre, and you'd expect, visitor accommodation would be able to be established pretty much wherever they wanted. Okay, we'll keep what everyone's got to say, I guess. Yeah.
Well, we're not going to hear from Mr. McPhee, so I actually had a number of questions for him, so I'll ask you those questions. And you can feel free to answer or not answer. But again, I think, obviously quite well thought through evidence. So you're looking for a carve-out specifically for Paihia because Paihia is different. Do you accept that in principle, that Paihia is different for the reasons that Mr. McPhee explained in his evidence?
Yes, I do accept that Paihia is different. It is the tourist hub of the north, and it does have established visitor accommodation.
And obviously he says, thank you for going to restricted discretionary, but you don't go far enough. and I'd like it permitted for my client in Parliament, special circumstances apply. I'm just wondering what effect it is that you're trying to avoid by not allowing residential at ground floor area in pedestrian environments. What's the effect that we're generally trying to avoid?
Yeah. So generally we're trying to avoid the, I guess, the complex of establishment of commercial activities on that ground floor. So enhancing the vitalisation of the town centre, the street frontage view when you're walking about down the street, the use of verandas for weather and amenity. There's plenty.
Yeah, well, I was just going to say, well, you could have verandas whether you're residential or commercial. Is one of the issues, you know, not having dead space in a commercial zone? I think that, I mean, I've seen there used to be arguments about bank frontages in retail areas because they sort of saw banks as dead space, you know, not retail, but they have that form of retail function. And banks would have these really long frontages, and people would have to, you know, and the pedestrians would go, well, I can't be bothered going from here to there because I've got to walk through this dead space. Is it a similar sort of concern that if you have too many residential ground floor activities established, it will detract from the retail vibe and vibrancy of a commercial area? Is that part of it?
Yes, that is part of it.
Yeah. So it's to maintain or encourage vibrancy, the consistent rhythm of commercial and in particular retail tourism type businesses in Paihia. But then I suppose it potentially runs counter because Paihia really is the most touristy area in the district in that sense, isn't it? It's, of all the areas that would want to maintain that vibe and vibrancy, I can't believe I've used the word vibe. Yeah, it's defined. Don't use the Yorkie Unitary Plan definition. But yeah, to create that vibe, but obviously that's an outcome you don't want to threaten if you do allow residential ground floor. Would that be correct?
So I think there's two distinct things we're talking about here. So I still maintain that pedestrian frontage, ground floor residential or visitor accommodation is not appropriate in Paihia. So that's the core Paihia street, and that's differentiated in the plan with that pedestrian frontages. But stepping outside from that, further along to the north and the south of the I guess the hub of Paihia, we do feel like it could be appropriate.
Yeah, okay. And so let's just have a look at how he's drafted this provision. Have you given some thought to the approach in drafting that's been put to us?
I am still thinking was it didn't seem too bad. I haven't given a full assessment.
So he's sort of saying, okay, well I agree, we can't mess with the vibe in the pedestrian frontage. So assuming that the vibe is at its greatest intensity in the pedestrian frontage, I think we're accepting that principle, right? So if it's subject to pedestrian frontage, that's where you really want to maintain that consistent rhythm of retail frontage. If it's outside of that and only in Paihia, you agree that you're not going to be running contrary to those outcomes if it's outside.
Yeah, I still maintain that the pedestrian frontage needs to be safeguarded, and that outside that it may be appropriate, as already established in the location of some visitor accommodation and residential activity.
Mr. Chair, even outside that location, there are a number of restaurants, bars as well. So we do need to take great care in managing the vibe outside as well, because they also contribute.
I think right next door to that property, right? We've got the Tipsy Oyster.
So we need to make sure that we've got the balance right. But again, we do accept that it is different. We're just probably looking to promote something that's well thought doesn't trip over its own feet.
Yeah. At the moment, the site's more or less vacant. I think it's used for motorhome,
Yes.
isn't it?
Yeah.
That's the site I think I identified on Google site visit.
Yeah, based on my research, it was used as a
Overnight mobile home
Yeah.
parking.
What other activities are immediately around that? I mean, is there a church there as well?
There is a church and another restaurant facility that's set quite back on the road.
That's the LBV, that's the fish and chip
Fish
place.
and chip.
That's not operating at the moment, they closed?
For just for winter, I think,
Oh,
like or a month or something.
I haven't been to any of those establishments like Tipsy Horse and like that.
Not at all. Yeah, so you've got a bar location, a church, and a restaurant that's
It's
quite
pretty eclectic at the moment, but having said that, we're talking about in the future, guiding development in the future.
Mr. Chair, I think it's probably fair to say that we are coming in terms of our spatial kind of planning. We're early on in that journey. So in terms of the granularity and forward thinking and spatial delineation of uses and activities, it's probably in its infancy. We have projects underway, the district-wide spatial strategy that's launching as we expect, that will go out and talk to our communities about what level of assessment planning provision they would like. And I see the part of the role of that moving forward is to identify in a more granular and community-based way some of those activities, how they work together well, and what we promote and what we protect. So I think we are where we are at the moment. I think we're at the start of the journey spatially. I think people will look to move forward on that journey. I think it's reflected in us. And probably it is notified blunt mixed-use zone, which is what it is, and for particular reasons. I think we've started to really refine that where we have the ability to do so at this time. But I think we're at the start of the journey.
Okay, no, that's good. Mr. McPhee's recommended a change to NUZ05. And he's taking out that last bit of the sentence. It says, except where the interface is with an open space zone. Have you got a comment? I mean, I was going to ask him why have you struck that out?
Yeah.
I mean, I'm not asking you to channel his thinking, but I'm just wondering whether you've got an opinion on why that would be struck out.
I don't have an opinion at this stage, Mr. Chair. I can report back.
And then there's recommending changes to NUZ P5. I can understand why A has been taken out, restrict, and then put in manage. And then you've got an avoid policy at A. And I'm just going to ask the question. I think you could probably read my lips. Why do you have a manage and an avoid in the same policy? And is that going to cause an issue at implementation phase if you're going to manage at the front of the policy and avoid as your first sort of limb of that policy?
Yeah, when I'm drafting often polls, I like to be quite clear on the types of activities we're focusing on for the whole of that policy. I think so using conflicting terms within one policy could be could cause some issues at the phase. So I would prefer to separate out avoid policies.
Yeah, I mean, it's Mr. McPhee who's literally offered the avoid wording with a manage at the front of it. And so the question, well, I would say, why have you got manage at the front of the policy and then you've offered avoid after that? Is it just avoid with regard to that thing? And if you're satisfied with that, it would be interpreted that way, then maybe that's appropriate. Or do you not use avoid when you're leading a policy with manage?
I would not recommend conflicting the two types of policies.
You have two separate policies.
I would have two separate policies.
Yes, I was going to say, if you're going to accept his, look to try and make his evidence work, you maybe look at how you would draft that
Yeah, I think there would be a separate policy for avoiding residential and sort of accommodation on the
So-
ground floor and the pedestrian frontage. I would keep that quite separate.
As a separate policy.
As a separate policy.
So that would be
And-
sort of MUPXXY.
Correct. I think it's clear if you separate those two out.
It's interesting in the context of his evidence at the one time that there's a number of questions and a number of points of discussion, he's not here. And then other times, like at Aramahoe or the like, he's, sits there rather quietly and lets his clients would work at it and wraps up at the end, which is an excellent way of dealing with it. But this is one which we could have had some useful discussion on. But be that as it may, it is good evidence. Yeah.
I highlighted one of the statements and I was going to put it to him, but again, I'll let you can answer on behalf of council. In paragraph 41, it says, the current recommendation in the 42A report is a half measure that creates an inefficient and internal conflicted planning framework in the context of Paihia. And I sort of thought, whoa, that's quite a big comment. And I thought I'd give you the chance to respond to that particular statement.
Yeah, I guess he's getting at that it's, we've made some movements, but we haven't gone as far as he would have liked.
Yes, yes, I was going to
sort
say,
of
so is it really
yeah.
inefficiently and internally conflicted still?
I believe the approach I've recommended, wholesale throughout the mixed use zone, is appropriate and is restricted to discretionary. I have, as he's mentioned, moved from a discretionary activity for the mixed use zone as a wholesale, but yes, he's directing this to Paihia and saying it's a half measure because he wants that permitted status. And as we've chatted here today, I do think there is some merit in moving
Okay.
to.
Okay, great. Well, thank you. That's been really helpful. Got any more questions on this?
If we were to permit more ground floor, development, residential in Paihia, would we be, in your opinion, would we be pushing out the, retail, hospos, would there be less likely to be more licensed licensed premises if we had more ground floor residential?
I don't have all the information in front of me in order to answer that question appropriately, but as on
Your report
generally,
mentioned some of that.
generally, I think safeguarding pedestrian frontage, as we've mentioned, there is a mix of activities outside that pedestrian frontage. In this location, not.
So, staying on the McPhee evidence, I mean, he's obviously got the Fletcher's evidence, but I think we've talked a bit about that, because I think his evidence on behalf of Fletcher's was about the impermeable surface restriction in the heavy industrial zone. I'm just trying to see if there's anything else he raised in there. Are there any other things raised in that brief of evidence you'll have to comment on at this point? I think the main, I was going to say live again, I think the main thrust of that evidence was the impermeable threshold.
Yes, and I believe that ancillary activities.
Ancillary activities as well, yes. Yes.
He does talk about there being insufficient evidence to support an arbitrary percentage for the GFA for an ancillary activity.
Mr. Chair, I mean, it'd be interested to see, I think we did some mental arithmetic around what those could be, and it's probably fairly generous, I would say. So it's very generous for those sites, in my view. And one of the discussions that we had as a group, as a team, is that perhaps it is unhelpful to have a percentage. In fact, perhaps maybe we should introduce strict limits on what those might be. For example, caretakers accommodation, on-site accommodation, rather than general. It was again perhaps next phase 2 or incorporated into the Waipapa considerations of rezoning and plan changes. So to an extent, I agree with them. It is arbitrary. But I think conversely, I think it's overly generous, or at least not specific enough, in my view.
The response is, yes, it is arbitrary, but it's in your favour.
It should, in my opinion, it should be a requirement. You can have a scope to do that.
Questions on that,
Yeah, I just question that division there. When in doubt, go the opposite direction of the officers.
Sorry, Robert, did we want to break for morning tea before we
I was going to
return?
have a morning tea break now.
Yeah.
I'm more than happy to do that. I was going to go more into the Z evidence, but
Yeah.
we can talk about that later. I'm sure we're going to have a few more breaks. So I'll telegraph that.
It's a useful discussion.
Yeah, this is really helpful. I mean, we usually have this chat at the end and we're crushing it. We're usually crushing it, we're all over it. So it's actually really helpful for us to sort of dive into those briefs where you're not going to have that expert here and the chance to give a bit more. And then it gives you the chance to think about what you want to include in the role prior to it. Okay, so let's have morning tea.
Okay, I will stop the recording and mute the room.
We're going to start again at 10 to once Mr. Barnett Thompson comes back.